Senator Cruz, over to you.
Thank you, Mr. Chairman. It's the first time I've ever been introduced to Senator Hirono. It's good to be with you. Welcome to each of the witnesses. Thank you for being here. Mr. Shapiro, let's start with you. You and I have known each other. We've been friends for north of 20 years now. You've been at Cato a long time. You do an awfully good job. For Cato, you've worked on a lot of amicus briefs. Let's start off at the beginning. Are amicus briefs some sort of deep, mysterious tool for dark money to deceive the United States Supreme Court?
They are not. And the disclosures that are currently in place about whether you've been funded by a party or whether the brief has been written by a party demonstrate whether there's any conflicts like that. Beyond that, it's just someone having a problem with the organization generally.
I guess I could understand the concerns of the majority. I mean, after all, amicus curiae is Latin for corrupt purveyor of lies, is it not?
Well, there's some dispute now, I suppose, whether it's really a friend of the court or a friend of only the party that you're supporting. But I take your point.
Mr. Fisher, General Fisher, it is good to see you as well. You and I served as fellow solicitors general in Indiana and Texas, respectively. You've been doing this job a long time. From your perspective, what is the importance of amicus briefs filed by the state attorneys general?
I think it's critical that the court understand what impact its decisions may have on states. I think there was a time when the states in the Supreme Court, the status of states in the Supreme Court was not really what should be in our constitutional system, where states have sovereign authority. And the Supreme Court rules, as you know, give states the right, when filing under the name of the Attorney General, to file an amicus brief in the Supreme Court. And I think it's critical that we do that in cases where we have an interest, so that the court understands not simply what the federal government might think about an issue, but what states think about issues as independent sovereigns.
What do the initials CVSG stand for at the Supreme Court?
That is for calling for the views of the Solicitor General, typically used with reference to the Solicitor General of the United States, but occasionally, and I've seen at least one circumstance where the court has called for the views of the Solicitor General of the state of Texas.
So the Supreme Court finds the views of amici helpful. It has a formal process to regularly calls for the views of the United States Solicitor General, and indeed, the United States Department of Justice is the most frequent amicus before the court. The court has also called for the views of the Solicitor General at the state level as well, so the court itself has recognized that amici can be important. And indeed, with some regularity, the court allows amici to present oral argument. Is that correct?
That has happened in a number of instances, and indeed, I can think of at least one instance where the court invited a state to make an argument as an amicus, and so I think it finds that sort of input very valuable.
Well, and General Fisher, I will note that when your office was defending the state of Indiana's photo ID law for voting, I was at the time SG of Texas, and drafted an amicus for a number of states in support of Indiana's law. And when that case went to the U.S. Supreme Court, the state of Indiana prevailed. The court agreed with Indiana. The court agreed with Texas and the other state amici, and upheld the requirement of photo ID. The decision was 6-3. Justice John Paul Stevens, one of the most noted liberals on the court, wrote the majority opinion upholding Indiana's photo ID law, and explained that photo ID laws enhance the integrity of elections and protect the right of voters to cast legal votes and not have those votes diluted by illegal votes that are cast fraudulently. Is that right?
That's what the court said, and we were grateful for the reasoning and the outcome, and for the support of Texas as amicus in that case.
Mr. Smith, it's good to see you as well. You You have long experience as a litigator and Supreme Court advocate. What do you see as the role of amicus briefs before the court?
Well, as I'm sure you know, Senator, I've filed many of them, and I think the court finds them very helpful. Many of the ones I filed do, in fact, contain what you would call legislative facts for organizations like the American Psychological Association. And I think the court needs access to some facts like that. And as Professor Larson said in her written testimony, the court draws lines between the people, the briefs it trusts, and the briefs it doesn't trust a lot of the time. My concern is, though, when they pull facts out of the air that aren't well supported even by amicus briefs, and those facts end up being ossified and become kind of facts as a matter of law that all the other courts in America are forced to accept, even if they're not true.
So I guess one of the more notorious examples of that would be Justice Blackmun's opinion in Roe versus Wade, which reads like, I think, a poorly written medical journal where he opines on a whole series of medical facts that we've since discovered, many of which are incorrect. Would you agree that the majority opinion in Roe versus Wade included a whole lot of things stated as facts that are found nowhere in the trial court record?
I'm not an expert on that case, but it is certainly true that the opinion is very facty, to use Ms. Larson's term, and there is a considerable controversy about much of what Justice Blackman said way back in 1973.
Thank you very much.
Thank you, Senator Cruz. Senator Hirono.
Thank you, Mr. Chairman.
For the mix-up.
Thank you, Mr. Chairman. I don't see how anybody can look at either the Shelby County or, in fact, the Citizens United case and